Happening now in Asheville, the trial over a lawsuit against a right-wing group known for using disguises and hidden cameras to uncover alleged bias and corruption. A disabled woman is suing Project Veritas,
who claims she was then libeled in a video
produced by Project
Veritas and founder James O'Keefe.
Shirley Teter says the group released a video 1 month after the assault. She says that video led to online threats, which made her fear for her safety.
So we're in the middle of this week-long jury trial. I'd never been in a jury trial. I mean, it was the most adrenaline, nerves, stress. With the jury, which I had helped pick the jurors, it felt like I was gambling on a roulette wheel, and for that reason I couldn't sleep for 2 days. I believe that this is an attack on the First Amendment and the press in general by people who politically disagree with us, and we will be victorious. So we're in the middle of a jury trial, and it was really extraordinary, almost like To Kill a Mockingbird level stuff. You had this extremely sympathetic plaintiff, and I think the opposing lawyers were betting on this issue because our side couldn't figure out what law or facts existed that would prove a case. So we're day 3 in, and we come into the courtroom and we sit down, and the federal judge, a guy named Martin Reitinger, he decided to put the brakes on. He decided to just shock everyone and issue this ruling that would make First Amendment history.
With regard to the motions pursuant to Rule 50, and I wanted to let you know kind of what I had in mind with regard to the motions that were made on behalf of the defendants.
So the day before, we had called these 2 witnesses to the stand. The plaintiff rested her case, and our case brought our witnesses. And there was only 2 witnesses. They were only 20 minutes long, and it was, I think, 4 or 5 o'clock, and the judge said, let's try to get these 2 witnesses in before we rule on some motion stuff. So these 2 witnesses just had some things to say that questioned Shirley Teter's credibility. They testified that she walked up to her assailant and touched him on the shoulder, and he sort of swatted her away. Some things that questioned her or impeached her credibility. And then these 2 witnesses were done being cross-examined by the plaintiff, and the judge had to hear arguments for something called a Rule 50. Now, I'd never heard of a Rule 50 before. I didn't even know what it was. Apparently, it's an opportunity for the judge to throw out the case before it goes to jury verdict. That means that there is no evidence whatsoever that would lead a reasonable jury to find our guilt. So at that moment, Jamie Dean, my attorney, is blind. I mean, literally 100% blind, gave this unbelievably passionate, articulate, organized, coherent argument before this judge. He's unbelievably brilliant, and he had memorized all these cases, Supreme Court cases, appellate court cases in the Fourth Circuit. Jamie had 2 arguments: that there wasn't any actual malice, there couldn't be any malice, and there wasn't any defamation per se. There was a scene change, there was a point in the video where we transitioned to talking about something else, and the opposing counsel was saying that everything in the video defamed Shirley Teter, even things that were said minutes later. And Jamie just decimated that argument because he said there was more than one possible interpretation. So therefore, there was no defamation. For 30 minutes, this man who's carrying a walking stick in court stood up and made this argument. And I was in awe. I mean, I was staring up at Jamie. And the judge seemed, to me, to be in awe. He was just sitting at the bench, just listening intently without interrupting him. And then I was waiting for the judge to interrupt Jamie, but he never did.
Your Honor, the burden of proof can't be ignored in these cases. The First Amendment requires a heightened burden of proof. The Supreme Court has guided that burden of proof must be considered on a directed verdict. So, a scintilla of evidence isn't sufficient. There has to be enough evidence that a reasonable juror could find clear and convincing proof. Ms. Teter has not met her burden of proof. She's presented, she's had her day, she's presented all the evidence she wanted to present. We would argue that the story here, even if Ms. Teter had denied that she was one of Mr. Fovel's activists, that doesn't undermine the value of the reporting. The story is that Mr. Fovel took credit, that a highly placed Democratic operative took credit for Ms. Teter. And that has relevance in the news, even if Ms. Teter denies it.
So what this lawsuit was about, we had released these videos in the 2016 presidential election, and it showed this high-level operative, dirty tricks operative, working for Americans United for Change, itself working with a group called Democracy Partners. And this man named Scott Fovel, we filmed him referring to a woman named Shirley Teter. Now, Scott Fovel did not mention Teter specifically by name.
But she was one of our activists.
She was one of your activists
who had been trained up to bird dog.
This was a pretty significant thing, that we were being sued by Teter. When I first got the lawsuit, I thought, why isn't Teter suing Scott Fovel, who made all the claims about her? And she sued us. So it was sort of our methods were on trial, and also this absurd notion that we're being sued for what we reported somebody else saying. In the judge's verdict, one of the things that has struck attorneys around the United States is just how clear he makes the constitutional implications in this particular case.
I believe that the First Amendment implications also extend to a greater degree in a case like this. The free exchange of ideas requires a very broad latitude for the media, particularly on issues of great public importance. And at the top of the list would be an issue regarding who should be elected as our president.
It doesn't matter what the frickin' legal and ethics people say. We need to win this motherfucker.
Hillary is aware of all the work that you guys do, I hope.
The campaign is fully in it.
And then they tell Hillary what's going on.
Well, Hillary knows through the chain of command.
Yeah.
I'm not suggesting we wait around. We need to start this shit right away.
Okay.
On every one of these fronts.
Okay.
Therefore, if citizens and the media are handcuffed by a fear of liability, that's detrimental to political discourse.
Going back to the To Kill a Mockingbird thing, I think for me that this whole thing was something to behold. It seemed to me like logic and law and reason and facts versus emotion versus the sympathy card. There was some intangible thing that they were trying to build up that had nothing to do with defamation law or the First Amendment. They were betting on this other thing. And I knew that. I knew that there were certain principles that were on trial here. It wasn't even really about me or Project Veritas. It was about principles and that versus what they were trying to create. So for me, this whole thing was kind of the manifestation of principle versus emotion, and the reason why Project Veritas exists in sort of legal argument form, because it's stuff that we contend with on a daily basis, just happened to be all there in the courtroom.
In this case, we've seen hours of testimony about Ms. Teter that have nothing to do with our publications, but that could engender sympathy. We've seen hours of testimony about the defendant's journalism methods, which don't bear on actual malice, but that could, for some people, engender feelings, prejudicial feelings.
So Jamie Dean, the blind lawyer, who gave a 30-minute long, incredible argument with the judge listening intently, Jamie finishes, and the judge just pivots, the federal judge pivots to the opposing counsel, a woman named Dixie Wells. And if you look at the other side of the courtroom, there's 5 or 6 people sitting, like a gaggle of attorneys. And everyone who has taken a look at this case and people who visited the courtroom has asked me, why do you only have 2 attorneys and they have half a dozen people? I don't know. To me, something seems afoot. One of these guys is from Ohio. Apparently, he was affiliated with the Bernie Sanders campaign. And Teter says that she was a Bernie Sanders fan. I don't know what's going on there. But it was strange. I don't know how Shirley Teter affords all of these seemingly high-priced attorneys. But the judge pivots over to Ms. Wells and says, Ms. Wells, what do you have to say? And for the next, 20, 30 minutes, unlike the 30 minutes where Jamie Dean was speaking uninterrupted, the judge constantly interrupts.
We believe that there's evidence that, first of all, and very simple, Mr. Hartsock, in the interview with Mr. Fovel, could have easily said, now you mean Shirley Teter.
Well, you say, could have said. In other words, you're now saying that an element of actual malice or proof of actual malice can be from the interviewer not having done a good enough job?
So here we have an investigation. We have an interview where the interviewer did not take what would appear to be a very elementary step.
I need to stop you there because that's one of the things I've heard recurrently through this case, that the argument troubles me.
And then the judge said something that I will never forget, ever. Sitting federal judge brings up Mike Wallace and CBS News, which was, I was looking at Ms. Wells, I was looking at the judge, this back and forth where the judge is saying something in his own way, a federal judge, constitutionally appointed federal judge, saying what I'm feeling. He's articulating what's in my heart, but saying it in a way that is more profound and more direct and from a position of authority than I could ever have. He looks at Ms. Wells and basically says, what if they did this to Mike Wallace?
I realize Mike Wallace is dead, but I think about in terms of, well, if Mike Wallace did that, could someone have sued him? And if Mike Wallace conducted an interview of some person, and then that person sued Mike Wallace and CBS, alleging, well, there was actual malice there because Mike Wallace just didn't ask enough questions, how quickly do you think that case would be thrown out of court? It just seems to me that that sort of standard for any type of journalist is one that eviscerates the First Amendment, doesn't it?
Your Honor, I do think it would be very hard to say to a journalist the fact that you didn't ask a question is actual malice.
I'm very concerned about making any ruling that is not only detrimental to the First Amendment, but eviscerates the First Amendment. That's why I keep running that Mike Wallace analogy through my mind. If you made this argument against Mike Wallace, would everybody in the room laugh? And with candor, Miss Wells, there are some parts of your argument that if you made that argument about Mike Wallace, people in the room would laugh.
So in the discovery process of a trial, there's something called the deposition, where these people put you in a room. In my case, there were 4 of these attorneys in this room with me asking me these questions. And you're under oath. It's like a root canal. I mean, it's brutal. It's brutal. I've been through this, a dozen times now, but it's like a root canal. And you're sitting there, and they've got binders and binders and binders of all of your emails, the names of the people that you work with, and they're asking all these questions about you. And in my case, as a journalist, I'm relatively uncomfortable about this because most newsmen don't like to be asked questions about their sources and methods.
Well, there is some confusion about this, but we try to avoid disclosing the identities and the names of our undercover journalists because that could compromise the work that we continue to do as investigative journalists. And there is a storied tradition of protecting sources and methods inside investigative journalism.
but I understand that I'm held to a higher standard, a different standard, which I think is one of the things underlying, the reason why we're on trial here and the reason why it's unfair. But in any event, I was asked questions like, what do I think about Shirley Teter? And they're trying to get me, it's clear in these tapes, they're trying to get me to say my opinion or trying to make a case for something that was other than what my reporting was. You could see it at one point during one of these depositions.
Was Shirley Teter a bird dogger?
I can only speak to what Scott Fovel said about Ms. Teter.
Well, was she?
I can only report what Scott Fovel said about these incidents.
What's your opinion?
My duty as a journalist is to report accurately what people tell me. That is the extent to my duty. So I don't tend to include my opinion in much of what we do at Project Veritas.
The first two rounds of questions are essentially, Mr. O'Keefe, will you in fact vouch for the 100% veracity of your source? No journalist would do that. No lawyer would do that. But then it goes to, well, what's your opinion? Well, a journalist's opinion about his source is utterly irrelevant. I would question the ethics of a journalist who opines about the opinions, about the veracity of the people he reports on. That's not what journalists do. I mean, that's what pundits do.
I would question the ethics of a journalist who opines about the opinions, about the veracity of the people he reports on. That's not what journalists do. I mean, that's what pundits do. I just sat there and listening to what the judge said, and I thought to myself, how often is it that your life's work is validated by a Article III appointed federal judge who has tenure for life? How often, these are the things that I feel and have been thinking for my whole life, that I believe so strongly, like in the core of my being, that the most important thing is to report what the people tell you accurately. At least only do that. And this man is saying that, basically contending with the other side who wants me to do something other than that. And he says, no, it's the inverse. One ought not to do anything other than that. One might be unethical if they did something other than that. I have no words. I have no words to describe the feeling it felt like. The only word I can think of is justice, the sweet justice of hearing this man who has the authority under the law to say the very thing that belies why we exist. And he said it. And he said it at just the right moment to this person who I felt was trying to change the law into something that it ought not be. And I don't have any words to describe the feeling. Of course, it would even get more interesting as things would unfold. So one of the things that they asked me in the deposition as I was testifying was, what about this so-called scene change where you're filming Fovel making these statements and then you cut to another scene? And we always get attacked for editing. I think it's just BS, but this one transition they would keep focusing on, we cut to a scene of Fovel months earlier. Remember this woman? Her name is Shirley Teter. She is a 69-year-old sufferer of COPD. According to numerous news stories at the time, she was assaulted at a Trump rally in North Carolina by Trump supporter Richard Campbell. The media played her story across the country for days.
She was one of our activists.
She was one of your activists
who had been trained up to bird dogs.
Yes.
So the term bird dogging, you put people in the line at the front, which means they have to get there at 6 o'clock in the morning, so they're getting the front of the rally, so that when Trump comes down the rope line, they're the ones asking him the question in front of the reporters because they're pre-placed there. To funnel that kind of operation, You have to start back with people 2 weeks ahead of time and train them how to ask questions.
Right.
You have to train them to bird dog.
No, I'm saying we have mentally ill people that we pay to do shit. Make no mistake. Over the last 20 years, I've paid off a few homeless guys to do some crazy stuff, and I've also taken them for dinner, and I've also made sure they had a hotel and a shower, and I put them in a program. Like, I've done that.
And Fovel's talking about the other things that he does. He recruits homeless people. He recruits union guys who are rock and roll. He says, quote, mentally ill people he pays to do shit, unquote. This is what Fovel was saying. And they were trying to make the argument, which is I thought was ridiculous when I was asked about it, is, well, all this other stuff over here relates to Shirley Teter. Now, interestingly enough, when that argument went to court and the opposing counsel, Wells, was making the argument, the judge bought none of it.
Your Honor, proximity and where. This is a clipped video. This is clipped and sliced. They chose where to put the content, right after the talk about she was, remember this woman. The very next thing is, I'm saying we have mentally ill people that we pay to do stuff. Make no mistake. That's the very next sentence, Your Honor.
And the very next one after that is about unions. So why isn't it a statement about Ms. Teter being a union member? Where is the line? Because all of that part you are talking about right now is in that different clip where he's wearing different clothing. It's obviously from a different time.
So by now, this judge is just rebuking systematically every single argument that Wells, the opposing counsel, is making. So at this point, Wells starts coming up with pretty spurious arguments. She starts talking about how Fovel was an unreliable source because he's saying all these just unethical, I guess, incriminating things. And I'm sitting there listening to Wells thinking, well, wait a second. He's not credible because he's making arguments that incriminate himself?
Did I have any qualms is your question. I'm sure I had qualms about everything he said. We were reporting what we were learning from him. What he was telling, we were reporting what he was telling us.
What did you mean you had qualms?
Moral qualms.
What do you mean by that?
His antics, as he described them, I found to be morally objectionable.
We have a reliance on an unreliable source. Mr. Hartsock said, I had qualms about everything that Scott Fovel was telling me.
He said he had qualms about the morality of what he was doing.
Well, Your Honor, if you have qualms about the morality of everything that a person is telling you they're doing, doesn't that put an idea that perhaps they're not being completely truthful or candid? Or maybe you should take a further step to investigate.
Under the rules of evidence, a statement against interest is considered more of greater veracity. And you're saying, well, if it's somebody who's admitting to something that's morally reprehensible, it should be less believable. I mean, it's the exact counterpoint of what we find in our own rules of evidence. So I'm having trouble following your logic.
So then the lawyer transitions to, I guess, some type of attack on our methods of surreptitious recording, which, by the way, has nothing to do with the case. Has nothing to do. There's nothing illegal about recording someone as long as one party is present. And as long as the person knows they're being talked to, it's a conversation, and you're reporting via recording what is taking place. So the counselor was trying to bring up this point, and again, the judge had none of it.
Your Honor, you've called it an interview, and I may have slipped and called it that as well. This was taped at a bar in different places where the person did not know that they were being interviewed.
He knew.
Then Wells makes the case to the judge, clearly grasping at straws, and the judge kind of said that in so many words, that they had sent us a retraction letter asking us to correct our reporting, and of course there was nothing to correct. We stood by reporting, and tried to make the case that the fact that we got this retraction letter and didn't act upon it was evidence of actual malice. And I'm not a lawyer and I didn't pass the bar exam, but I had listened to enough arguments to know, first of all, that's absurd. But second of all, it can't be negligence or actual malice if you're informed about something well after the time of publication. So this is an attorney making this argument. and I just thought to myself, that doesn't make any sense. On principle, I wouldn't publish a correction about something, first of all, that I accurately reported, but this occurred well after, I mean, maybe even a year after the actual publication of the videotape of Scott Fogle making the claim.
After a retraction letter is sent to them, before this lawsuit's filed, they don't do anything, so...
What does that have to do with actual malice here? I mean, that's in a totally different context. That's what's done or not done after the publication, or after the accused document is set forth. What does that have to do with whether or not there was actual malice in the publication of the document? You're saying, oh, it's the big picture. It's all the pieces together. And it seems like every piece that you point to is a piece that hurts your argument rather than helping it. And you can't have a bunch of minus ones and add it up to 20. It just doesn't, it's just not math.
So back to Wednesday morning. I'm walking to the courtroom. I'm 10 minutes late. It's 9:10, and the U.S. Marshals take my phone and they make me put it in a locker, and I'm busy on my phone. I know that I'm late. I know the jury has probably assembled, but I'm okay with it. And it's like 9:07 or 9:08. I know that there's been deliberations for about 10 minutes, and I walk into the federal courtroom and I hear the judge talking. And I walk in. I know my attorneys weren't really thinking that this judge was going to rule on this Rule 50. It never happens. As far as I'm concerned, it's as rare as a unicorn. So I'm walking in the courtroom and I hear the judge saying, "I will start with a point of extreme bias." I hear those words. I'm walking up to the wooden bench to sit behind my lawyer, and I'm thinking, well, maybe the judge is about to talk about he's biased in favor of the First Amendment, but I didn't know where he was taking it. And I heard him say something like, "I have enormous confidence in juries, that's my bias." I'm thinking, this is going to go to a jury verdict. The jury, he is going to let the jury rule on this case because he talks about how biased he is in favor of juries. And then, as I'm listening to what the judge is saying, I hear him say, I'm sitting there, I hear him say, but I also recognize, said the judge, the arguments on both sides, and because of the, quote, First Amendment implications in this case, the issue of Rule 50 warrants close examination. I'm sitting there thinking, well, that's interesting. So he's going to get into that discussion, but maybe he'll still rule against us. After all, it is just a discussion. The judge even says he was pretty hard on Ms. Wells, so maybe he's going to let this go to jury. The judge says when there are First Amendment implications, there are great societal implications. So the judge goes through and systematically dismantles all the 5 points that the opposing counsel had put in their motion that they had given to the judge that morning. We had given our motion the day before. And at that point in the conversation, the judge talks about this thing about reeds, the thinnest of reeds, and cited the Supreme Court, this lobby case, and said, I have to make a decision about whether the jury could even possibly find clear and convincing actual malice.
Any one of these points, if they are evidence at all of actual malice, would constitute really the thinnest of thin reeds. And these very thin reeds, which I believe, as to several of these, are really no evidence of malice at all, are insufficient to meet the standard.
So I was sitting next to my executive director, Russ Verne. He was sitting right next to me. I looked at him, he looked at me, he sort of winked at me. And I put my hand on his thigh, like bracing myself for what may be about to happen, which I couldn't believe could possibly happen. I was waiting for the words out of this judge's mouth, and he's going through this monologue, and he says he says something like, I believe that there really was no malice at all, that this is insufficient, and he says, therefore. And I have my hand on Russ's knee, and Russ has his hand on my shoulder. And the judge says, therefore, for that reason, the defendant's motions pursuant to Rule 50 will be granted.
Therefore, for that reason, the defendant's motion pursuant to Rule 50 will be granted.
And I'm just stuck in a state of complete paralysis. And one thinks that people rise up and shout, but Jamie and Mike Montecavo and Russ and I, we didn't want to move. We didn't want to do anything to disrupt this extraordinary moment. They had actually ruled in our favor, and the judge just nonchalantly looked over at Ms. Wells and said, "Is there anything else we need to address?" The judge issues this ruling, and of course, the first thing that the plaintiffs may be thinking is, well, I'm going to appeal this, and the judge is assuming that this might happen and preempts it and makes this extraordinary statement about, listen, you can check my homework, you can appeal this up to the guy upstairs who's going to take another look at this. And this judge makes this extraordinary statement saying that if I'm wrong on this issue, then we're in trouble, guys.
If I have gotten this wrong, and the Fourth Circuit says that this is not what the law is, I hesitate to think where the First Amendment is going in this country.